Hello and welcome to Data 2021, the UK, EU, Brexit, and what you need to do now in order to be ready. My name is Peter Wright. I'm the Managing Director and a solicitor at Digital Law. We are a law firm that focuses on advising businesses on how to work in the digital environment. So everything from buying and selling goods and services online to providing professional services, accessing new markets online. So as you can imagine, this year we've been helping a lot of organisations as they've shifted a lot of their operations online and trading digitally and trying to make the best of that in the difficult situations that we have found ourselves in 2020. But despite all of that, we now find ourselves facing a new challenge. So we've got quite a few attendees on today, and welcome to those of you who are joining us for the first time. There are lots of ways that you can stay in touch with Digital Law. We have a Facebook page, so just go on Facebook, type Digital Law, and you'll find us. We're also on LinkedIn. We are on Twitter at Digital Law UK. And for those of you who like to stay up to date with what's happening in the world of digital law and technology, we also have a weekly update that we broadcast as a webinar, which you can then watch on demand on our website, www.digitallawuk.com. And that also goes out as a podcast. So for those of you who like to have something to listen to when you go out for a run or walk the dog, then just search on Spotify or on your podcast app of choice, and you'll find our podcast there. So plenty of ways to stay in touch with developments as they happen all around the world. But in the meantime, I'm going to take you through today the impact of the UK leaving the European Union, the fact that the law as it currently stands means there are a few things that we need to do, and the fact that, to be brutally honest, I don't think this is something that is being talked about enough when it comes to talking about the end of the transition on the news coverage at the moment. So I'm afraid this will sound a little bit like one of those terrible UK government coronavirus briefings, because I'm going to be occasionally saying, next slide, please, and that's what I'm going to say now. So next slide, please. There we go. So why is this changing? Why the change indeed? We have the end of the transition period. So as you probably know, the UK formally left the European Union in January of 2020, which now seems a very long time ago. Indeed, I heard someone say recently that, yes, you wouldn't know it, but 2020 has now been going for 5 years. It certainly feels like it. But indeed, back in January, the UK formally left the European Union. We've been in a transition period ever since. So as far as data is concerned, data has been able to flow very easily from Europe to the UK and from the UK back to Europe with no problems, no issues, because the rules of membership of the EU have continued to apply. So it's been like as though the UK was still a member. However, from January, the UK will become a third country, and this will apply no matter the outcome of the current negotiations. The UK is aiming for a trade agreement similar to the one it has with Canada and similar to the one that the EU has with Japan. So there will just be a similar agreement to that between Europe and the UK. But that's very different from membership. Now, membership meant that we had this free flow of data. However, we no longer have that with the end of this transition, and that's where the problem comes in. So if we go to the next slide, please. There we go. So indeed, most of the coverage that we've seen with the media has focused on a lot of the practicalities in terms of exports. So whenever at the moment you switch on the news or you read anything on a website, there's usually stock photographs of car ferries and trains and containers and lorries, and lots of people talking about exports. And I think that has made a lot of people think, well, if I'm not exporting something in terms of a physical item, you know, manufacturing a good, putting it in a box and sending it to Europe, I think an awful lot of organisations are falling into the trap of thinking, well, this doesn't apply to us, we don't have to worry. But as I say, for looking at the coverage of the negotiations, which talk about issues around fish and the level playing field, actually data is a large part of this. So it's not just in relation to physical items that we export, it's also down to the more ephemeral data. What do we mean when we say data is going to be affected by this? So if we go to next slide, please. We're talking about personal data. So personal data cannot leave the European Economic Area after the 1st of January. That's under GDPR, General Data Protection Regulation, as adopted across the entirety of the European Union and the European Economic Area. The European Economic Area is the 27 EU member states plus Norway, Iceland and Liechtenstein. The idea is the personal data can freely flow around there under GDPR. However, it is a problem if that personal data of EU citizens should leave the European Economic Area. In order to allow data to flow from within the European Union outside of the European Union, you can have this thing called an adequacy decision. So there is a list of countries that have adequacy decisions, and this includes Canada and Japan. They both got their adequacy decisions after the trade agreement had been agreed between the European Union and their country. But for example, New Zealand also has a adequacy decision. Adequacy means that the European Commission has looked at a country's data protection laws and has said, we think that your data protection regime is adequate, i.e. you have enough safeguards looking after the personal data of the citizens in your country that we feel we can have the personal data of EU citizens flowing into your country without there being any problem, because you have sufficiently adequate data protection laws. However, it is not clear that the UK will get such an adequacy decision from the European Commission. So first of all, this isn't something that's part of the negotiations. It is not as though in any free trade agreement that might be announced in the coming days, there won't be a paragraph that says, yes, data can flow freely from the European Union to the UK. That is not the case. It is something that would follow. It is kind of ancillary to the negotiations in that it would follow a free trade agreement, but it's not part of the free trade agreement. So this actually leaves us even more uncertain, because if we do get, say, an 11th hour agreement, some sort of free trade agreement being announced, on Christmas Eve, and then it's a matter of, it takes a few days to be ratified in Europe and the UK, there would be, do we get adequacy following from that? We don't know, but it seems unlikely, and that seems to be is part of the difficulty. So therefore, we have to plan for, I'm afraid, the worst. Hope for the best, but plan for the worst. And I think there's another reason for that. One is that we can't necessarily guarantee that we will get an adequacy decision in time. But there's also the fact that the European Union has made it quite clear that because of the UK's surveillance laws, whereby under the Investigatory Powers Act, things like bulk surveillance take place. So the fact that bulk surveillance can take place of, say, all of the personal communications by everyone in a city over a 3-month period. We'd like to see all of your text messages, all of your emails, all of your phone calls. That sort of thing can be granted under the Investigatory Powers Act under the bulk surveillance laws that are possible. That's not consistent with EU data protection best practice. Now, you might say, well, hang on, why is this a problem now, but it wasn't a problem before? But it turns out you can get away with this stuff if you are a member of the European Union. However, if you're outside and you're asking for the slide rule to be passed over your country to confirm that your laws are adequate in relation to data protection, they do take account of the surveillance laws. So therefore, things that you could get away with inside the European Union, turns out you can't get away with them when you are external. So it's a bit like, in order to pass through the eye of the needle, you actually have to show that you have better standards than if you were actually a member in the first place, ironically. But there you go. So it is what it is. But therefore, it is not guaranteed that you would get an adequacy decision by the end of this year on those several counts. So there's no guarantee it's going to come. So therefore, what do we have to do in the meantime? So if we please go to the next slide, please. I think it's important to emphasize that we are only talking about personal data. So if we're talking about confidential data, if we're talking about sensitive, commercially sensitive data, that's of course very important, but it isn't covered by what we're talking about today in terms of European law changing on this and the fact that we'll have to adopt certain measures come the 1st of January. So this only applies to personal data. Next slide, please. And this is the key bit. How do we define personal data? There's a lot of things. The strict definition is anything that identifies an individual is personal data. So that is anything that allows an individual to be identified from a cohort. So, for example, your name. That's fairly unique, isn't it? Your home address, an email address, a car registration number, things like a bank sort code or account information, medical data, so things like date of birth, a photograph, a visual image of someone identifies them, as does a video recording, so things like CCTV or the videos on a mobile phone or a mobile device, they are personal data. As is an audio recording of this webinar today would contain personal data, as would an IP address. That is also personal data. So, there is a lot of data to take account of when we're talking about personal data, and that means really that the average data set will contain some data like that. So, if we're talking about data being stored on a contact management system, if we're talking about sales invoices, if we're talking about HR data, if we're talking about a voicemail recording system, CCTV, all of those things, of course, contain personal data. Next slide, please. So indeed, there is an awful lot of information that this could include. Anything that you keep in the cloud. So if, for example, you are storing data in the cloud, if those servers are in the European Union, then that's going to fall foul of this. It could include specialist systems. So if you've got like a specialist HR system that you use for recording your data, for recording, details of staff, payroll information, recording the dates when they're going to take leave, recording the dates of sickness and absence, recording training records, that sort of system is containing personal data. Even if you are running an app to deliver services to your customers, that's going to store client data, that's going to be on the cloud more than likely, and that is going to be storing personal data. So things like, as well, if you've got a case management system, a document management system, if you've got a voicemail system that allows, for example, for your staff to access their voicemail from a mobile device or via their email, then that is going to be based in the cloud more than likely. And if it's in the cloud, that means it's on someone's server somewhere. And very often that somewhere, if you're in the European Union, as the UK has been for the last 40 years, therefore that data tends to be stored on servers in the European Union, and the majority of those servers are located in Ireland for various reasons relating it to BitBrook. But in short, it is a very friendly country for tech companies to make their base. Everything from a comparatively lighter touch regulation through to quite a beneficial tax system has meant there have been various reasons why everyone from Apple to Facebook to various other organizations, AWS, Amazon, have all chosen Microsoft Office 365. They've put all of their servers in Ireland. So we're looking at an awful lot of that data being based there, which means it's in the European Union. So if you're accessing that data in the UK, that data is being transferred from the European Union to you. Even though your organization might be the data controller and you're the one who owns the data, you're the one who's acquired it, you're then storing it with the processor, it's being stored, retained, transmitted to your order. The fact is that data is still then being processed and returned to you. So you're the data controller, you're the owner, you're making decisions about it, but the processor is holding it to your order on their cloud services. So while that data is being processed in Europe, it then is subject to the issue that we're talking about here. So that includes as well things like telecommunications, as I say, voicemail, and if, for example, you are then doing video calls, as you may have done this year. So if you've got a video conferencing system, if you've been doing large conference calls to allow for a more distributed way of working this year, recordings of all of those things will also constitute personal data and will be subject to this change. So if we go to the next slide, please. So in short, if you do process this data, what do? You need to rely on safeguards set out in GDPR that govern the transmission of data beyond the European Economic Area. These are the 4 things you can put in place. I'm going to go through these briefly, and then we're going to go through each one in more detail. Binding corporate rules are a mechanism that you can use if your organization has, say, multiple offices either across Europe or around the world. So if, for example, you're an organization with an office in London and Prague and Berlin and Riyadh and Singapore and Melbourne, if you're a global corporation, offices all around the world, you can have binding corporate rules that will allow for data to be shared freely within your organization, within your company, or your corporate group of companies or corporate structures that you have, allowing for those organizations to function in different countries. Then you can use binding corporate rules. These are very strict rules set out that govern how personal data will move around an organization, and they are signed off by a data protection regulator. Standard contractual clauses are the clauses that can be added to third-party data sharing agreements. That, for example, if you're using a contractor to process data and you're located outside the EU and a processor in the EU is processing data for you, you'd make sure that these standard contractual clauses are in the data sharing agreement under which that data is being processed. Another option is to have certifications or codes of conduct. This can be used by different organizations. For example, we have a Digital Law 1 client, which is a large membership organization with hundreds of thousands of members all around the world. And they have put together a code of conduct, which is also something that they're working on with the data protection regulator. But the point is that if you've got that code of conduct, that can also then govern data being passed around within that organization. Some professional bodies are also investigating how to do the code of conduct in the same way. And finally, derogations, which can apply to EU data exporters only. So for an EU organization exporting data outside of Europe, there are certain derogations within GDPR. But I think it is worth making the point that the European Data Protection Board, which is the board made up of representatives of all of the European data protection regulators, has made it clear that they would expect the derogations to be used sparingly. They don't want to see them used in a blanket way. They don't want them to see them sort of used and abused frequently. And I think if you are applying on one of these derogations, it's still a matter of making it quite clear in your corporate governance that you are relying on that derogation. So in the same way that you would physically have standard contractual clauses appended to a contract, or you would have binding corporate rules in your company's handbook and then as part of your training staff, the derogation, you would want to have a document that says we have assessed this data transfer and we're relying on this derogation, and you specify the derogation, you specify how it's being applied, more than likely in a fairly limited specific manner, and you would then rely on that in the event that derogation was used. But in all of those instances, it means that you've got a physical item, a document, a mechanism you can refer to. So and if you get the tap on the shoulder from a data protection regulator that says, right, what is the basis upon which you are sending this personal data from within the European Union to a country outside? And you can then at least refer and say, we're using this derogation, we've carried out an assessment, we're of the view that this derogation applies, and we've applied it, this is the basis upon which we are using it. So it's not just in the event the regulator does get in touch, you don't then get to say, well, we've done nothing, but we thought we were okay because we were covered by the derogation. Is that all right? That's not going to be the method that they expect organizations to use. So those are the safeguards. This is the change. You have to have one of these four in place come the 1st of January in the absence of the adequacy decision that we have already discussed. So next slide, please. Binding corporate rules. So these are fairly detailed. The idea is you would have very essentially page after page, a small book of binding corporate rules that would govern how personal data can be used within an organisation. It would specify the technical measures that will be used. So, for example, secure servers, encryption. It might specify methods of instant messaging to be relied on, encryption, secure portals, as well as training that all new starters would receive, as well as refresher training that all existing staff would receive. It might also detail any certifications that the organisation will achieve. It might detail mechanisms for transporting personal data from one jurisdiction to another, so across different servers. They would also detail everything in terms of what happens in terms of, for example, the backup of personal data, because you don't want to find that, oh, if our primary mechanism goes down, suddenly all that data is scattered on the four winds. We have no idea where it goes. So you'd want to be very clear how the backup works as well. You'd also want to have things like making sure that any onward data transfers to other third countries were limited and proportionate. So there would be a lot of detail in binding corporate rules. They are not the work of a moment, he says, having been responsible for several projects implementing binding corporate rules. It tends to take several months to get them in place, to draft them, and then you've got to go through a process with the data protection regulator to get them signed off. So that isn't straightforward either. So if you're listening to this for the first time and you haven't got binding corporate rules in your organisation and you're thinking, that sounds great for us, it would be very difficult to get, well, difficult if not impossible to get them in place before the 1st of January. What you could potentially do is start work on them and have a live document that is being developed, so that you can turn around and say, we do have binding corporate rules in place, we're refining them, and we're then going to submit them to a data protection regulator. But in the absence of that, you know, you can't sort of turn around and say, yes, we've got the belt and braces bulletproof binding corporate rules in place already. If you are working towards this, you might want to actually approach the UK Information Commissioner and say, let's just, you know, what can we do on this? You may also, if you have offices or physical infrastructure in Europe, whichever office you have in Europe where key decisions are made with regards to that personal data, i.e. controlling it, transferring it, wherever those key decisions are made, the data protection regulator in that country becomes your lead data protection regulator under GDPR, and they are the regulator that would have to sign off binding corporate rules you could then use across your organisation. Though it is also worth highlighting that at least under GDPR, you only have to work with one lead GDPR data protection regulator in Europe. So, for example, if you've got an office, you might have 5 offices in Europe, but your office in Paris is the one where all the key decisions are made, then you'd be getting in touch with the French data protection regulator, CNIL, and you would work with them to then get some binding corporate rules in place. So if we go to the next slide, please. That should then take us to standard contractual clauses. Now, these are going to be the method for the majority of sort of SMEs out there, where you might be relying on third-party cloud storage, cloud software, cloud mechanisms. Where that is the place, you're going to be relying on having standard contractual clauses in place. Now, because you are data controllers, you own data, you are responsible for that data, it is your responsibility to ensure that any of the organizations that are providing you with terms of service so that you can use their services, so for example, Microsoft, Amazon, Apple, all of these organizations, you are still required to go and approach them and confirm that they have updated and have got the correct standard contractual clauses in place on those data sharing agreements. I cannot emphasize enough that you cannot just rely on thinking, oh, they're big multinational corporations, they will already have done this, we don't have to worry. It's important that you can demonstrate that as a data controller, you have turned around and you have used all of your reasonable best efforts to ensure that standard contractual clauses are in place. None of us want to be in the position of finding that come the 1st of January, access to your personal data in Europe has suddenly been switched off. And you might think, well, that couldn't possibly happen. But you've probably seen some of the rhetoric over the course of the last week, where at one point there have been threats from the French fishing fleet. They're going to blockade ports and stop UK ships landing in Europe. when the rhetoric gets to that level, who knows what the potential measures that might end up being taken could be. You know, could an EU member state's government turn around and mandate the providers in its country to turn around and block all UK IP addresses from using the service? We like to think it couldn't possibly happen, but what if it did? Hope for the best, plan for the worst. If it did, you would want to rely on and say, we have standard contractual clauses in place. I approached the provider. I spoke to them in advance of the 1st of January. They confirmed that they will be continuing to provide their service. They confirmed that standard contractual clauses were in place. We have a physical copy of the terms with the standard contractual clauses here, for example, and you can then say, look, we've done all that we can get expected to do as a data controller to prove that we are discharging our responsibilities to ensure that data can freely pass from the European Union to our organisation. So that, in short, is the standard contractual clauses. They are not small paragraphs. They're actually quite lengthy annexes. They are about 10 years old now. There are 3 different versions, one for controllers and one for processors. And it is important to ensure that you have the right ones on your data sharing agreements. I should also add that there is currently a consultation exercise underway for the review and updating of these standard contractual clauses because they are 10 years old. The first standard contractual clauses were actually devised and included in a judgment of the European Court of Justice, where it said these are the clauses that should be present on contracts where personal data is going outside of the European Economic Area, and it mandated what these clauses should look like. However, of course, the world's changed a bit in the last 10 years, so the European Union has consulted on what the next standard contractual clauses should look like. They'll be releasing new ones in 2021, and there will only be a grace period of a year or 18 months until they can be put in place. But I have had one client recently turn around to me and they said, well, can we just wait until those new ones come in? And the answer is no. We need to ensure that you are doing everything that you can now to ensure that you can continue to operate and receive any cloud-based services as of 1st of January 2021. You can't wait on these, unfortunately. Next slide, please. So codes of conduct are, again, fairly detailed. They are something that are useful. For example, if you can't necessarily do binding corporate rules, if your corporate governance or organisation is looser than that. So, for example, you're looking at a membership organisation, or you're looking at a broader organisation or a broader collective than just a corporate group, then a code of conduct might be the way forward. Again, these are very long and detailed. They cover the same sort of detailed issues that I talked about when it came to binding corporate rules. And again, these should be signed off by the Information Commissioner's Office. So they are another solution that may be worth looking at. But again, they would take a period of many months to draft, get them signed off by the ICO or the Relevant Data Protection Regulator, and then get them in place. Next slide, please. So derogations can apply as well, but as I said earlier, you need to make sure that if you're claiming a derogation, you have evidence that you are taking this derogation and explain why you think it applies and why you're using it. So this is a matter for the EU data exporters to say. So if, for example, you get in touch with your EU data exporter that's providing services to you, and they say, we are relying on these derogations, then you're going to have to take that statement, take the derogations that they are applying, and make sure you've got that on file, got that on record to say this is the basis upon which we are continuing to rely on for the delivery of this service. I would also want a correspondence paper trail with that supplier to say, look, we have raised issues with you with regards to the UK leaving the European Union, and we have your written assurance that services will continue onwards after the 1st of January. We have your written assurance that you are specifically relying on this derogation in terms of your supply of services to our organisation, so that you've then got something to rely on, so that you aren't left in extremis on the 1st of January or at some point in 2021, suddenly finding that you can't access the systems that you need. Next slide, please. So what do you need to do now? You need to know if you have data going into the EU. Check your contracts. Make sure that if you are using cloud-based services, that you know where that server is located. If you're using cloud-based backup, make sure you know where the servers are that data may end up being sent to. This may be a matter of specifically checking your contracts, specifically making sure that they contain the right standard contractual clauses. So, I mean, as I say, these are fairly lengthy documents. They are not just 1 or 2 paragraphs that you'd find embedded in the contract. It is going to be very, very clear when you're going through a contract if it contains these standard contractual clauses, more often than not as an annex or an appendice to a main data sharing agreement. But once they're in place, you can rely on being able to then receive that data. If you carry out this exercise, if I were you, I would then get in touch with the supplier offer services, confirm you've got the most up-to-date version of their terms, because they may have updated those terms with a view to the fact that the UK is leaving the EU, so they may have updated those terms, they may have updated it to include these SCCs. You might want to get in confirmation from them in writing that they intend to continue providing services after the 1st of January, come what may. It just proves then that you are doing, as an organisation, you're carrying out your due diligence as far as you possibly can. Next slide, please. So it may be a matter of that UK-based firms will need to assist the EU in their data supply chains to ensure compliance. It's a matter very much of, I think, we as UK-based organisations, we have to speak to these organisations in the EU to say, are you aware of the need to do this? Have you got the measures in place? And are you doing this to support your UK-based customers? Because they may not be aware. I say, do not rely that a large organisation is on top of this. Do not assume that they are taking the right measures. We need to discharge our responsibilities to show that we are doing all we can be reasonably expected to try and stay on top of it. Next slide, please. So, practical measures here. What can we do? The ICO has built a builder that will generate controller, processor, and controller as standard contractual clauses that you can use. So if you are able to go through your contracts, if you find they don't have the right clauses in there, or if you are indeed putting together contracts for your customers, whereby they are going to be relying on these services, then you may wish to make sure that you have the right controller, processor, or controller clauses in those terms of service. They put together templates, and there's a lot of really useful information there on the ICO site. Of course, that is free to use. It's in good, clear, plain English. I think it's fairly clear to follow. And if you do nothing else as a result of this webinar today, I would highly suggest that you follow the link that we've provided for you there in full, so that you can, or even just Google ico.org.uk / go to the tab that says for organisations, and they will have this information in relation to the transition period. It's really, really good information. The ICO is, of course, the UK's regulator, but in all of the advertising and stuff even I've seen on the government's own transition website, it's not flagging up tools like this enough. And I don't think there's enough information on there to allow business leaders and managers to properly get on top of and understand these issues and properly be able to take the measures that we have talked about during this discussion today. So definitely go and take a look on the ICO website and take a look at the tools. It's there, it's nice, clear, plain language, it's free to use, and at least you can start getting a handle on the work that you then need to do in relation to getting on top of this issue. So, next slide, please. Multinational businesses, yes, you can go down the route of then adopting binding corporate rules and getting those wheels in motion. But the problem is that it's going to take a while to do that. So you would probably want to contact the UK ICO, and if you've got then any offices in Europe, I would contact the lead data protection regulator that your organisation is using there, and ask for some guidance, ask for some help, ask for what they are expecting to see from you and your organisation to demonstrate that you are working towards getting those binding corporate rules. Don't forget that different data protection regulators will have different mechanisms in place in terms of what they expect when it comes to the signing off of binding corporate rules. So you can find out what the data protection regulator in that specific country is doing, what hoops you have to jump through in order to get those binding corporate rules signed off as quickly and speedily as hopefully you can. Next slide, please. So what can we specifically do for you at Digital Law? We can review some contracts for you. So if you've just got a load of contracts and you're like, I don't know what I'm looking for, I don't have the manpower to do this, half of my department's already finished for Christmas, then we can review individual contracts for you, £200 plus VAT per contract. We can add specific standard contractual clauses for you. The fee is to be confirmed, because depending on the information that you've got, there might be information to be populated in those standard contractual clauses, but we will be able to agree a fixed fee per contract for adding in the standard contractual clauses for you. If your organisation relies on the cloud in order to be able to provide goods and services to your customers, and those cloud servers are based in Europe, you may wish to have the standard contractual clauses in your terms specifically, so that you are saying to your customers, look, we're a UK-based organisation, our servers are in Europe, we have put the standard contractual clauses into our terms, here they are. And you would also want to make it clear that you have spoken to the provider of the service, that you've got their undertaking that they will continue to provide that service for you, and that there should be no effect with regards to the provision of services. So we can update your organisation's terms and conditions to confirm the measures that are taken to satisfy due diligence. And that we can do that for a fixed fee of £450 plus VAT per contract. We can also help if you're looking at having binding corporate rules drafted. We've done those for our clients. We've done codes of conduct for our clients in the past. Obviously, that varies from client to client. All organisations are different and have different needs. So it would be, in that instance, we would have a chat with you to understand exactly what your needs are, and then we could look to draft with you a code of conduct that works for your organisation. Don't forget, of course, that binding corporate rules will change depending on the sector that you're in. So if you're in financial services, your binding corporate rules are going to be very different compared to if you are in a manufacturing industry, which in turn will be very different compared to if you are in professional services, if you were, say, an accountant's firm. So therefore, those binding corporate rules will vary from sector to sector and from organisation to organisation. But we work with you if that's what you need to do to get binding corporate rules in place. We have a very good relationship with the UK regulator, the ICO, so we can get in touch with them to let them know what you're doing, and we can also then work with them on the sign-off for those binding corporate rules if that's what you would need to get in place. Likewise, we've also worked when it comes to codes of conduct with organisations to get those in place. Sometimes that requires a degree of consultation. Sometimes there can be multiple different IT systems, multiple different types of data, multiple different data collection sources, all things that have to be taken account of when it comes to then putting together data codes of conduct that work well. So we can work with you to put together those codes of conduct. We can also work with you, we've talked about derogations, so we can work out if a derogation might apply in this instance. So if you are a EU data exporter, we can work with you to ensure that to see if a derogation applies, and then put the right mechanisms in place to ensure that you are demonstrating the use of that derogation to the customers and service users that need it. If you are an organisation relying on another EU data exporter that is relying on a derogation, we can work with you to extract from that data exporter the confirmation that you can then rely on that that derogation is correct, and we would also review how that derogation is being handled. So there's lots of ways that we as Digital Law can hopefully help you and work with you to be able to demonstrate compliance, or to demonstrate that you've done as much as you fairly and reasonably can in the run-up to the 1st of January. Obviously, time is short. We don't know still what's going to happen. It's all very much up in the air, isn't it? We don't know if we're going to get a free trade agreement. We don't know if the adequacy decision will follow. So we can work with you day by day to get the right measures in place so that you can at least demonstrate come the 1st of January that everything will be able to continue unaffected for your organisation, hopefully as far as possible. There we go. We've got, you can ask me any questions that you might have. Please do feel free to type them into the chat. So I've got one question here. Please clarify whether personal data sent by the data subject whom the data relates is caught, as I understood, that it was only a business in the EEA sending personal data which is relevant. So we're talking here about personal data within the European Economic Area being passed outside of the EEA. So if you are a UK-based organisation and you have UK-based customers, even if you are then passing that data and using EU facilities, because you're taking that data and it's being stored in Europe, that's where you then might struggle to get access to that if the worst happens, as it were. So therefore, it's a matter of, if we've got personal data and it's relating to UK data subjects, and it's being passed into the European Economic Area, and that's where we may potentially have a problem. So that's where you need to then make sure that you've got standard contractual clauses or one of the other measures in place that we have discussed so far. That's one of the questions we have there. Please do let me know if you have any other questions. I'm just going to share with you now a few insights that I've had from a few clients that I've been working with over the last few weeks in relation to this issue. So one of my clients is a web developer, was saying, do we have to do anything on this now? Can we wait till January? To which my answer was no. You need to make sure that you are doing something about this now. You need to have something that you can point to and demonstrate to a regulator, be it a UK-based data protection regulator, the ICO, or one of the European regulators, to show that you are trying to end up getting access to that data should you need it. So you definitely need to have that. And it's something that you need to be doing now before Christmas rather than waiting till afterwards. Another client of mine was saying, well, can we just wait for a year or two until the new SCCs come in? And as I say, no, you can't do that. Just because the status of the standard contractual clauses is that they will be changed within the next year to 18 months. We cannot rely on that as a reason not to put standard contractual clauses in place. Another question. Is the use of mobile phones for businesses under threat? No, but it is the use of, if you're using, for example, voicemail, or if you're using servers for any of your telecoms that are based in Europe, that's where you would want to make sure that one of these four mechanisms is then in place. So even if you are using a UK-based communications provider, it depends then who is providing the voicemail or the other business telephony services that you might be relying on. So, I mean, if, for example, you have business mobiles and you have pocket landlines, so i.e. someone calls a local phone number, 0208, whatever, and that gets put through to your mobile phone, that's probably going through a cloud server somewhere. So I would speak to my telecoms provider or your business telecoms broker if they provided that service for you, and ask the question, you know, presumably we've got servers providing this service, where are they located and do we have standard contractual clauses in place? And then you're putting the burden onto them. They then have to confirm that this has been done. You are asking the question, you're then needing an answer. And to be honest, any organisation worth its salt should be the one contacting you to say, we have updated our terms, here are the standard contractual clauses that are on here. So in short, is the use of business mobiles for business under threat? No, but you do have to, as I say, investigate the sort of methods that are being, the tools that are in place for the provision of services like voicemail, like conference calling. So if you've got conference calling that allows you to port in multiple callers into a call, if you've got video conferencing that is allowing for, you know, multiple people to be on there, then where are the servers being used for that? This is something, for example, if you're using Zoom, then you want to confirm that Zoom has got the right measures in place. I highlight Zoom because they haven't had the best record this year when it's come to, for example, their security and encryption measures. They were found wanting earlier this year. They are facing a class action from their own investors for having given assurances in 2019 their systems were secure and encrypted, when it turned out that they are not. So consequently, any warranties that you receive from Zoom, I tend to subject to fairly rigorous scrutiny to say, can we really rely on what's being said here? Can we get independent verification that they have actually got the measures in place that we need to rely And it's for that reason that certainly when it comes to, if you're, say, in a highly regulated sector, if you're in law, banking, accounting, anything like that, I really do question whether you should be using something like Zoom for that purpose, because it's the concern that its systems simply are not secure. And indeed, when you start asking questions like, where actually are your servers? Sometimes you don't get a very clear answer. If you get a clear answer back that blinds you with silence and talks about, oh, well, we're in multiple locations, like, right, okay, well, how many of those are in Europe and how many aren't? And what measures have you got in place to ensure that data will continue to flow after the 1st of January? So sometimes it just means making a bit of a pain of yourself and just having that correspondence trail that you can then rely on to say, look, I did ask Zoom, or I asked Teams and Microsoft and Amazon, whoever it was, we did have this conversation with them and we were given assurances, you know, in blood that this was going to be something we could rely on. And at least then, if you've done that, you can at least turn around to your colleagues, turn around to your regulator and say, look, we did check on this, we did all what we thought we could reasonably be expected to do. And we've tried to make sure that everything will still continue from the 1st of January. Got another question. I'm a developer that's just started a new project. I'll be using cloud for data storage. Where should I host my data to be GDPR compliant? We have, let's just click down there. We'll have customers in the UK, the EU, and eventually the USA. So when it comes to your data in providing services to EU-based citizens, data subjects, though you would need to have a server based in the EU in order to do that. When it comes to your customers in the UK, if you've got the standard contractual clauses in place, allowing that EU-based server to supply data to you and to your UK-based customers, then that will suffice. But you do need to have that demonstration of compliance from the EU-based server. If you were hoping to put all UK data of all your EU users in the UK, that is more complex because technically UK is outside of the EU. So without an adequacy decision, that would be problematic. You've also asked the question there about the USA. Now, the USA doesn't have an adequacy decision either. It never has. There was a mechanism called the EU-US Privacy Shield, but that collapsed in August on the back of a decision of the European Court of Justice, which said because of the surveillance laws and practices in the US, we are unable to feel confident that companies that have subscribed to the EU-US Privacy Shield are actually providing the right secure mechanisms that they need to have. So they withdrew the Privacy Shield. At the moment, technically, organizations in the US are having to supply on those same full mechanisms I've outlined to you today in order to ensure that data continues to flow. We are told that in 2021 there will be negotiations between the European Commission and the US presidential administration, and that may lead to another sticking plaster on this, another Privacy Shield type mechanism. But because this is the second time that such a mechanism like that has been in place and then found wanting due to a decision of the European Court, I wouldn't put any money on it holding in the long term. So increasingly it's becoming a problem to share data between the US and the European Union. So that's why I wouldn't rely on servers based in the US for the storage of personal data of EU citizens. So whoever's asked that with regards to them being a developer and they're working on that, if you want a more specific conversation about that in relation to international data sharing with regards to where servers should be, I hope that's helpful. But if you'd like to have a more detailed conversation on that, just drop me a line and we can schedule a conference call to go through that and we can answer your specific questions that you might have. Another question, we provide MS365 to our UK customers. MS365 servers are global. How do we approach Microsoft about this? Yeah, this is difficult. Microsoft has kind of fudged the question of its EU GDPR compliance. It has servers in Dublin, but then as you say, the servers are global. A particular problem is that if the EU servers get busy or they go down, suddenly your data can be distributed far and wide. And that potentially puts organizations in technical breach of GDPR, which obviously no one wants to be in that situation. So this is problematic. This is part of the problem of the MS365 architecture. This is one of the reasons why we actually encourage our clients to avoid MS365 for that reason, particularly, again, if you are in highly regulated sectors, because it's coming to the point where I can rely on the security and integrity of the system in order to properly comply with and discharge an organisation's responsibilities under GDPR. If you are providing these services to your UK-based customers, you're going to want to make sure that Microsoft has got in place in its agreement with your company these standard contractual clauses. I would want that in writing. I would want it in writing that I've asked them that question. I want it in writing. When I say writing as well, I mean in an email or in another form of electronic communication that you can at least keep on file via a screenshot if it's via instant messenger or whatever. But you want to make sure that you've got a documentary record, that you have asked questions of Microsoft. You want to make sure that these standard contractual clauses are in place, make it clear that you are ready to work with them in order to do that. And try and be sympathetic with them. It could be that they say, yes, we've done this, it's fine. If they haven't, then speak to your contact at Microsoft, say, look, we need to have this, and work with them to achieve that result. But you want to make sure, if you are a customer of MS3 of Microsoft and they're providing that service, you'd want those standard contractual clauses to be part of the terms of service. You may find that in their wonderful terms of service, which are already like 30 or 40 pages long, you might find they're already in there and that they actually followed a belt and braces approach in the first place. But you might also want to then amend your terms with your UK-based customers to make it quite clear that Office 365, make it clear the nature in which the servers operate, make it clear that you have asked these questions of Microsoft, that you have asked and you're working towards getting SCCs in place, because ultimately you might get your own UK-based customers now contacting you and asking you the same question. So if you can then assure them and say, look, we have taken these measures, you might even want to put the standard contractual clauses in as an annex to your terms of service, as a sort of belt and braces approach. So you can basically say to your customers, here are the SCCs that we have in the data sharing agreement that we have with Microsoft. So I hope that's helpful. So we're now coming up, I've got time for a few more questions if anyone would like to ask them, but that's all of the questions that we've had asked so far. So I'll start to wrap up there, but thank you all very much indeed for listening today. If we go to the next slide, hopefully we've got our contact info on there. Thank you very much. So we've got, you can drop me a line there, peter.wright@digitallawuk.com. You can take a look on our website, www.digitallawuk.com. We're on Facebook, Digital Law UK, LinkedIn, just search Digital Law UK, and Twitter @Digital Law UK. And you've also got our office contact number there as well. As you can imagine, we are open right up until Christmas, helping our clients, new clients, with this issue. So if you would like to come to us with any more questions, just get in touch. I'm happy to hold a conference call with you or colleagues, or if you're wanting to explain this to senior management, we can do a conference call so that I can have a chat and outline and explain some of these issues. Also, this recording will be posted live. This live recording will be on our website, the Digital Law UK website. We'll be posting it on there once the recording is available, and you'll be able to watch it, fast forward it, rewind it, find the links that we've referred to at your leisure. But thank you all very much indeed for watching and listening today. I hope you have found this discussion helpful. Please do feel free to contact us on the information provided there if there's anything you'd like to discuss. But in the meantime, I'd just like to say I hope everyone stays safe in this time of global pandemic. I hope everyone enjoys as good a Christmas and New Year as far as such a thing is even remotely possible under the current restrictions, wherever you are in the world. And I hope that I'd just like to wish you good fortune in terms of getting set in terms of being compliant, so that all of our organisations can continue to function safely and effectively in January 2021 and onwards. So best regards from me, and best of luck with all of that. And if we can be of help, just drop us a line. That's what we're here for. My name is Peter Wright. I'm the Managing Director of Digital Law. I hope you found today useful. I look forward to seeing you again soon. Thank you.